Harris?
Are you driving?
Just give me 1 second. I'm parking right now.
What are we doing?
Your Honor, we are respectfully requesting an adjournment in this matter, up possibly 24 weeks if the court would allow.
Okay. So maybe I don't understand something. And he was just driving, and he didn't have a license. Defendant is to turn himself into the Washington County Jail by 6 p.m. today. Failure to turn himself in will result in a bench warrant with no bond.
The video kicks off with Mr. Harris, who went viral for an unbelievable reason. He showed up to his court hearing on Zoom while driving. That's right. He's behind the wheel, trying to talk to the judge as if that's completely normal. The court quickly shuts it down, orders him to report to jail by 6 p.m. and makes it clear this is serious business. To his credit, Harris does the right thing. He turns himself in, posts bond, and shows up to his next hearing, thankfully parked this time. But just as his story starts to unfold, the focus shifts to a familiar face, Jeffrey Bloom. If Harris is the face of chaotic poor judgment, Bloom takes things to another level entirely. His courtroom antics have been dragging on for years, and with Judge Simpson's expression already showing signs of frustration, it's obvious this hearing is going to be anything but calm. Let's just say the judge isn't in the mood to play around today.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Bloom, who is present.
What are we doing today?
Your Honor, I'm going to be asking the court to set this for the final settlement conference. I know there's one in August. I know there's one in June. I do have a circuit court jury trial for next Monday that's like pretty firmed up. But I can make the August one work, and I'll leave that open, and we'll get it done.
Okay. Very final settlement conference will be set August 9th, 2024 at 9 a.m. Jury selection in this matter will be August 12th, 2024 at 8:30. Both of those proceedings are in person.
I'll let you.
I was going to try to get you. I was going to try to get you out of the room. I was trying to get you out of the room before you said anything. You knew what I was doing. That's why your finger went up.
At least I'm not right.
As soon as Bloom's case is called, Judge Simpson's tone says that all the case has been dragging on for over a year, and today's hearing is to finalize the trial schedule. Bloom's attorney requests a settlement conference and a jury trial. And everything seems routine until Bloom can't help himself. He tries to crack a joke about at least not driving on a suspended license. The judge immediately shuts it down, reminding him that domestic violence charges aren't something to laugh about, Bloom may think. He's being clever, but his attempts at courtroom humor fall flat, especially when the charges against him are far more serious than traffic violations. It's not the first time he's tried to deflect with sarcasm, but it's likely the last time this judge will tolerate it. This isn't open McKnight. It's a courtroom with real consequences, and Bloom is about to learn that again.
Good day, enjoy your horse, all that. So I let it go. The time before that, I let it go. But Your Honor, today I need to put something on the record. This is very serious.
Put something on the record all the time. Go ahead.
Okay, no, not last time. Okay. Your Honor, this case, assault and battery case, has gone over a year. And since October, I've fought tooth and nail for discovery. I still haven't been given a hospital report, any photos, any. There's a lot missing from discovery still. Remember, since October, we've.
No, I remember you mentioning it. But hold on a second, Mr. Bloom. Has the discovery been requested, Mr.?
Yeah.
This is why, Mr. Bernstein. Discovery referencing judge.
Hospital report that Deputy Swearing says there was a hospital report. There was. I'm wondering how this case was even brought about, Your Honor, because.
Okay, Mr. Bloom.
There was never a report, Mr. Bloom. Okay, I'll let it go.
Because you keep asking me questions, you know I can't necessarily answer.
Okay, let me get on with the real stuff.
Oh, okay.
For transcripts.
No,
I still haven't received the transcripts.
Of what?
3-6. Remember, I asked for the transcripts from 3-6. I still haven't received transcripts from 3-6. That's 3 months ago. I know it takes a while, especially this being a misdemeanor case.
Hang on. We have to have a written request for the transcripts. And Mr. Bloom, here's what I'm going to suggest. If you need those, Again, you have an attorney. Tell your attorney that's what you need.
Okay, well, this is my assistance of counsel, just like Ms. Barroso has assistants and you have assistants.
I don't have assistants. I have individuals that I work for that are professional.
Jeffrey Bloom dives straight into a familiar routine, ranting about missing discovery materials. He claims he's still waiting on hospital records, photos, police reports, and more, insisting he's been asking for them since October with no response. The judge, trying to remain composed, turns to the prosecution to sort it out. As it turns out, some of Bloom's requests were fulfilled, while others were never properly submitted. But it's hard to get through the details. Bloom keeps interrupting, speaking over everyone, making it nearly impossible to clarify anything. He then brings up court transcripts he says he asked for months ago, expecting them to be handed over without following proper procedures. The judge reminds him, again, that transcript requests must be submitted in writing. Still, Bloom pushes back, arguing the point instead of moving forward. It's a classic Bloom performance, turning every procedural step into a drawn-out mess. Whether it's disorganization or deliberate disruption, one thing is clear. He's only making things harder for himself.
It was just talking about, I ordered an audio recording of that hearing. And someone in my office kind of like, we did a transcription of it for Jeff. But I think what he wants me to request is an actual transcript. And I just didn't
Well,
pay for
and so they can do that, pay for it, and I'm sure it will be accomplished. But if we haven't received written requests for that, then that won't happen. So,
Thank you. Well, I ain't gonna go through all this. I just need to put a little bit on record. For transcripts from 10-4, you stated that you believe everything a Washtenaw County Sheriff
10-4.
22. Washtenaw County Sheriff Deputy says is true. And you believe everything a Washtenaw County Sheriff Deputy says.
Hold on a second. What are you reading to me right
Something that I want to state on record, Your Honor.
now? No,
Is that-
but what are
can I do
you're obviously stating what somebody else said. I'm just
No.
trying to figure out where it's
that?
coming
You said,
on the 24th of,
no, on 10-4 of 22.
in this case?
No, you stated that you believe everything a Washtenaw County Sheriff's Deputy says, correct?
I don't recall saying that.
And you were upset that my attorney questions the deputy's authority of authenticity and requested said officer to be under oath. And there is proof that deputy testified with reckless disregard for truth. You were also misled on 9/13, 10-4, and 11/7.
Mr. Bloom, is this in regard to your other matter?
This is regard to everything.
Well, no, it can't be in regard to everything. It's got to be in regard to your other matter because
I'm
this
trying to
didn't
put
start. No, stop. This case didn't start until 10/18. So if you're referring
Okay,
to
I'm
a
past
record from another case,
Then I'm past that.
then you're past what?
As if things weren't chaotic enough, Bloom suddenly pivots into reading aloud courtroom canons and judicial ethics guidelines. He accuses Judge Simpson of misconduct, citing ex parte communication and claiming personal bias against him. The judge, visibly caught off guard, tries to understand what Bloom is even referring to. But it quickly becomes clear he's cherry-picking rules from various cases, misapplying legal concepts like a self-taught attorney with a strong Wi-Fi connection. At one point, he even quotes hearings completely unrelated to his own case. Eventually, Judge Simpson has had enough. She cuts him off, says goodbye, and ends the session. You can practically hear the collective sigh of relief from everyone in the virtual courtroom. Bloom may think he's delivering a powerful legal takedown, but in reality, it's a rambling mix of confusion and conspiracy. This isn't a lecture hall or a podcast. It's a court of law. And with this latest performance, Bloom has likely just made his legal journey even more difficult.
Which in part reads, a judge shall not initiate, permit, or consider ex parte communications or consider other communications concerning a pending or impending matter that are made outside the party's presence or their lawyer's presence. Canon 3A4B in part reads, not only is it a gross breach of the appearance of justice when the defendant's principal adversaries are given private access to the ear of the court. It is a dangerous procedure.
What are you, Mr. Bloom? I'm going to stop you because what are you talking about?
I'm talking about the transcripts from 3-6, Your Honor, where you stated you had notes, you stated you had a phone call, from ex parte communicators.
No, that was regarding your dental.
Yes.
Yeah,
That was a motion we followed.
No, but that has nothing to do with the
But
case.
I mentioned that on
And
other things you did
but
that.
Mr. Bloom, no, Mr. Bloom,
You don't
because if
wanna
you're
hear
going to, you don't want to hear, I don't. Because what you're saying is incorrect.
Okay.
I had a communication.
All right.
I disclosed that to the parties because it came to the court's attention, not by the court doing it, that there was something regarding the dental work. I don't know what it was about the dental work.
There were other matters you did the same thing, Your Honor. I'm not
Goodbye.
Senior
Goodbye.
counsel.
Goodbye,
I'm
Mr. Bloom. Goodbye. Thank you. Have a great day. Thank you.
We'll contact the senior commission.
After Bloom's legal meltdown, the spotlight shifts back to Mr. Harris, the man who somehow thought it was a good idea to drive during his own court hearing. His new attorney tries to steer the conversation toward resolving the case, but Judge Simpson isn't ready to let the viral stunt slide. The court finally turns to the core issue. For months, Mr. Harris has insisted that his license was valid and that a bureaucratic mistake caused it to appear suspended. But then comes the twist. He's never had a license. Not in Michigan. Not in any U.S. state ever. Judge Simpson lays it out plainly. You can't have a suspended license if you never had a valid one in the first place. That revelation completely undermines Harris's entire defense. What he framed as a clerical mix-up is, in reality, a total misrepresentation. And now, the court's patience is clearly wearing thin.
How are you, Your Honor?
We will see.
We're good.
Mr. Brown, or somebody from the PD's office, because I did not get a substitution. I got an appearance.
Oh, I've got a substitution right here.
It's signed off on.
It is.
All right, then I don't need to address. I don't need to address the public defender's motion to withdraw. I'll consider that withdrawn, given the substitution. I do have an appearance, and I will sign off on the substitution.
Thank you.
Thank you. All right, what are we doing today?
So, Your Honor, we were going to, there's several options that my client,
Well, and I want you to know, counsel, that because of certain things, the court has a number of things I have to say.
okay,
Because I think the record, given particularly some of Mr. Harris's comments with reference to this court potentially acting what at least as I'm to understand is on what some may be, or is it, let's put it this way. People are saying, and quite frankly, your client has made the assertion that the Pittsfield Township, as well as this court, was acting on some type of defective or faulty information, which I will tell you, counsel, caused the court, given what the court did, to investigate what my ruling was. And I will tell you that that assertion is absolutely correct with reference to any faulty information that either came through to the Pittsfield Township Department of Public Safety or to this court ultimately at the May 15th hearing. And I think it needs to be stated, I've been asked for comments. I have refrained from comments as my normal practice is. This court with the pending case will speak on the record. And so I am going to make sure that the record is very, very clear as to what this court knows and what this court acted on May 15th. And we can start with this. And my basis for doing it is because of what was said about what this whole process was. And that an indication, counsel, and I know, counsel, you've been before me before.
Absolutely.
I know it is not coming from you, but you also know how I am.
I do.
And the thing is that if for whatever reason, the one time in my life I was wrong, I will say it and did. But when I'm not wrong and when people are not to blame, then it also needs to be said. So I will try to get through this as quick as I possibly can. But I will tell you, first of all, with any reference to your client having had a license on that day, and some indication or misunderstanding as to whether or not he had a license. Let me make it very clear, based upon what the court looked at, he has never had a Michigan license, ever.
Mr. Harris had argued that both the friend of the court and the Secretary of State had let him down, claiming they were supposed to lift the suspension but never followed through. But when Judge Simpson takes a closer look, the story quickly falls apart. Step by step, she reviews the facts. The friend of the court acted properly. The Secretary of State followed every procedure. There was no error. The only person who failed to act was Mr. Harris himself. He never paid the reinstatement fees, never checked on the status of his driving privileges, and never followed up. The court even reviewed communication logs to be sure, and confirmed that nothing had slipped through the cracks. Judge Simpson spells it out clearly. This wasn't a bureaucratic mistake. It was a failure of personal responsibility. And that matters, especially when you're asking the court for leniency. Instead of owning his actions, Harris built a false narrative. Now, it's collapsing in real time.
Suspended his license in Saginaw. They don't suspend the license. They suspend the privilege to drive in this state. Hence, for example, if he had had a Kentucky license, he would be able to drive everywhere that Kentucky would allow him to drive. He just couldn't drive in Michigan because his privileges had been restricted. I know you know that, but that wasn't at all said. But it doesn't matter because he didn't have a license. Ever. There is also been, and I will, when it is necessary, come to the defense of my sister courts, and I will come to the defense of Saginaw. They got a great chief judge. Chief judge answered the question. But I will tell you, that court and its friend of the court did nothing wrong. His license was his driving privileges, better stated, were unsuspended in 2022. That required Mr. Harris to do something. He didn't do it. Therefore, the friend of the court was under no obligation to send anything to the Secretary of State. Now, I hated that I had to look at all of this, but when there's a question as to what I did, I'm going to look at everything to make sure that what I did was all in order. There's been an indication from that because that wasn't sent, there was a direct attack on Michigan's Department of Secretary of State's office, saying that the Secretary of State was somehow at fault. Let me tell you something. Secretary of State did what they were supposed to do. And in point of fact, they did nothing because they hadn't gotten anything from the court because Mr. Harris had not paid the reinstatement. This week, or the latter part of last week, once he paid that, Saginaw friend of the court did what they should do, and they sent it. Immediately, based upon the information that I have, the Secretary of State did what they do every day. They took that suspension off of his driving record, and he was then unsuspended. And then your client did what he needed to do with reference to the Secretary of State and paid a refund. Okay. Just a second, Mr. Schiller. I'm going to let everybody respond because
Thank you.
I am not done yet.
Okay.
All right.
You're covering a lot of the points for me. Thank you, Your Honor.
And so that came down to that. So the information at the time that I had, that Pittsfield Department of Public Safety had, was all correct at the time of both Pittsfield stop as well as the May 15th date. It was all correct. There was no error by anybody. It was a failure on the part of Mr. Harris to do certain things. Now, I grant you that sometimes that can be a complicated process, but it was certainly not anybody's fault that that didn't happen other than that.
Mr. Harris told both the court and the press that he couldn't go to the Secretary of State's office because he was recovering from a car accident. According to him, he was housebound, physically unable to make the trip. That excuse might have held weight if it weren't for one glaring contradiction. Court records reveal that on December 28th, 2023, Harris did visit the Secretary of State in person and obtained a new Michigan State ID. Judge Simpson confronts him with the exact date, time, and transaction receipt. The lie is undeniable. What frustrates the judge isn't just the dishonesty. It's how pointless the lie was. Harris could have avoided much of this by simply telling the truth from the beginning. Instead, he chose deception, and now the consequences are stacking up. In court, a lie doesn't just weaken your defense, it defines it. And in Harris's case, that definition is becoming increasingly damaging.
Stop was in October. Most of the cases that we've heard just in this last afternoon are driving while license suspended cases. That's part of my Wednesday afternoon. We go through great pains to try to get people their licenses back, which is really how it should happen. Between October and because I don't live under a rock, I actually watch things. You look very nice on TV.
Thank you.
You're welcome. There was something that was said that was very disturbing to me. And I'm just going to let you know because I believe in being fair with everybody. The question was asked along the lines between October of 2023 and the point in time of the May 15th hearing. Was there an attempt by Mr. Harris to correct his license? Here's the part that was disturbing for me, so that you know.
Okay.
Mr. Harris indicated that at some point he had been involved in some accident. And being involved in the accident, that he was basically bedridden or at least housebound, he could not get to the Secretary of State. That was set up there, and I'm going to presume, because my knowledge of defense counsel is, I know you don't misrepresent anything.
Right.
You never do.
Right.
That's not true.
Okay.
He purposely stated that he could not get to the Secretary of State, which, for the way we handle things in this court, would have placed him in a whole different category. We would have tried to find a way. Let's figure it out. And the reason I know that is because Mr. Harris, on December 28th of 2023, do you know where you were?
December 23.
23rd.
2023.
I know I was laid up from my
You were
accident.
at the Secretary of State's office. And you were at the Secretary of State's office because you
Harris's viral hearing drive sparks national outrage. A now viral video of Mr. Harris driving during his court hearing has ignited a firestorm of controversy. News outlets rushed to cover the story. Social media erupted with reactions, and suddenly, everyone had a take on the situation. When reporters pressed for answers, Harris and his attorney argued that he was unfairly targeted, blaming system errors for the incident. But Judge Simpson wasn't buying it. After meticulously reviewing the timeline, court records, and the allegations, he delivered a blunt verdict. There were no system failures, no misconduct by law enforcement, and no justification for Harris's actions. The public narrative, it turned out, was built on a lie. And now, the scramble to contain the fallout is in full swing. This isn't just an embarrassment for Harris. It's a harsh lesson in accountability. Going viral doesn't make you the victim. Sometimes it just means the whole world gets a front row seat to your mistakes in high definition.
2023. It did. And so that you also know, and in all fairness to counsel, because I don't know if counsel knows this or not, the way I know that he's never had a license is because May 3rd, he was 19 at the time. May 3rd, 1999, he applied for his first Michigan ID. Counsel knows, so I do. You cannot have both. You either have an ID or you have a license. One of the two. He has religiously every year gotten a new ID. And so he knows that he doesn't have a license. And quite frankly, I just wish he would have said that at the beginning. And all of this hoopla could have been just put all aside. And we all go through the process as we do with all of the people coming here to try to get him his license back. But his falsehoods, misstatements are not going to fare him well in this court. I'm done for now. I'm sure I will have something else to say. Whichever one of you would like to speak first, you may.
I'll wait to go last.
Yes, I spent yesterday at the Pittsfield Township Police Department with Officer Monaster on the traffic stop in this case. I also noticed the December 28, 2023 date, and I know the significance of that, and the court just went through that painstakingly, and I thank you for that. In addition, at the traffic stop, when I was at the police department yesterday, we watched the body cam video. At least twice during this traffic stop, he acknowledged to the officer that he did not have a valid license. Quote unquote, quote, actually, I don't have a valid license. Close quote. The question was, are you a valid driver? Quote, I am not. Close quote. So, you know what, just all this in the circus atmosphere, in my opinion, is an affront to the justice system. I mean, I've been a prosecutor for more than 30 years, and to see this kind of hoopla around a driving while licensed suspended case is ridiculous. And it wasn't caused by this court. It wasn't caused by Pittsfield Township Police Department. It was caused by...
Harris's new attorney takes a softer approach, but the judge isn't letting up in an effort to defuse the controversy. Mr. Harris's new attorney struck a conciliatory tone in court. She commended the arresting officer for his professionalism and assured the judge that Harris is now taking steps to obtain a valid driver's permit. Judge Simpson listened, acknowledging the more measured approach, but made it clear he hadn't forgotten the earlier blame game. Harris's lawyer emphasized that her client didn't post the viral video and is focused on moving forward. The court agreed, but with a firm reminder. Harris lit this fire himself with his public accusations. The only way to put it out is with honest effort, not media spin, the judge stated. Asterisk. The road to recovery begins when the excuses end. Asterisk now. The ball is in Harris's court. If he wants to rebuild credibility, he'll need to prove it. Asterisk asterisk with receipts, not stories.
Very much. Well, first thing I'd like to say is, very first thing is we're here, and we all saw this video. I wasn't in court. I wasn't even on YouTube watching the court thing, right? I saw it because someone saw it and decided to post it. I can assure you that was not Mr. I don't think he has the capacity to be able to post it like that on YouTube or Instagram. So that was not him. And it happened to take off and go viral. So he had what we saw was him saying he was driving, which he should not have been driving, right? We're told not to drive on Zoom while doing that. So that's how this came to the attention, because the court, I saw you. He said, I can't believe this. Is he driving? And we all said that. Everyone who saw that video asked the same question. And that it became a joke. It became a complete joke. Now, with respect to what we want to do, and I cannot say anything is with respect to what my client has said, but when we talk about the hoopla, my client didn't start the hoopla. Perhaps he's made some comments, but he didn't start the hoopla.
Court takes unexpected turn as Harris's legal troubles deepen. Just as the hearings seemed to be winding down, the prosecutor dropped a bombshell. Mr. Harris has an active warrant in another city for the exact same type of violation. His attorney, caught completely off guard, scrambled to respond. Judge Simpson verified the warrant's validity, noting it should have been addressed during a prior arrest, but wasn't. Now, it's another hurdle Harris must face. Despite the setback, the court set a new hearing for July 17th, giving Harris time to secure his driver's permit and begin untangling his licensing issues. But the judge's parting words cut deep. Asterisk. If Mr. Harris had simply told the truth from the beginning, none of this would have happened. Instead, he chose deflection, blame, and denial. Now, he's learning the hard way. The truth doesn't just matter in court. It defines what happens next. Asterisk, the message was clear. Harris's choices set this disaster in motion, and only accountability can end it.